A very good afternoon to all the attendees of the first edition of the Lunch and Learn webinars. It is a series of webinars that we will conduct over the next 52 weeks, covering aspects of maintenance law, domestic violence law. We will address certain aspects of the Children's Act, everything that you would need to know regarding maintenance, domestic violence, and the Children's Act. Now, just afford me a couple of seconds just to introduce myself. My name is Eugene Opperman. I am a family law practitioner, and joining me during the course of the next 52 weeks would be a panel of experts delving into certain issues that could assist you in your maintenance application, also your domestic violence application, as well as your children's court applications, such as care and contact, parental responsibilities, visitation rights, parenting plans, and so forth. So that is what we'll do in the next couple of sessions. There is, just to give you some feedback, the purpose of these webinars are to educate people at large. And that includes maintenance officers, it includes the lay public, people want to claim maintenance, attorneys, social workers, mediators. All those people are welcome to join in and learn about the maintenance process and how to deal with certain maintenance issues. There are, like I said, every week there will be a webinar, and I will be joined by at least one expert on the matter, that we will have a short discussion regarding the issues that we will be discussing that certain day. So a couple of topics that we will be addressing in the upcoming webinars, and we'll start slowly about the process of maintenance. And these would always happen on a Wednesday between 12:45 and 13:45. So that would be during your lunch hour. So grab your cup of coffee, grab your sami, and get some information that is given to you by a panel of experts. We will start off today's topic with things that you should know before you apply for child maintenance. Then we venture into how to get all your documents ready for maintenance. And then most importantly, how to apply for maintenance using the J101 maintenance application form. We will go through step by step explaining every detail of that form that you need to complete in order to lodge your application at court. We will also discuss how to calculate the child's expenses, how to calculate the parents' contribution towards maintenance, and then it increases. And we will discuss how and when to refer a matter to court in terms of Section 10. After you've done the Section 6 informal inquiry, most importantly as well, how to interpret the documents presented to court during a Section 6 or Section 10. How does future maintenance work? We will discuss that in quite some detail. How does spousal maintenance work? What to do if the debtor or the respondent is in arrears with his maintenance? How to deal with that? What is your recourse? What can you do regarding that? And how to apply for garnishee orders. These are just a couple of things that's coming up until May. You can visit our website at www.lunchandlearn.org.za, and there you will find a complete detailed list of all the webinars that is coming up, and these are all presented free of charge. So the Lunch and Learn webinars are directed to legal practitioners, maintenance officers, maintenance support staff, NGOs, and even mediators that deals with issues regarding child maintenance, domestic violence, as well as the Children's Act. And it is an open invitation to anyone that is willing or able, that wants to volunteer to assist our Lunch and Learn team, to do marketing, or even to be a guest speaker. If you feel that you've got a topic that you want to address that you're comfortable with, please let us know on info at lunchandlearn.org.za. Please drop us an email, and then we can slot you in, and then you can actually present one of these webinars as well. We will also have a panel of experts joining us, and those panel of experts will be discussing fire-round discussions around the table on certain contentious topics that might be quite heavy and it might be quite interesting. Things that is upcoming is, for example, how to address economic abuse and how to avoid poverty. That economic abuse is actually the new pandemic of South Africa. We will be discussing the whole issue of mediation. For example, is it a viable option? Mediation in maintenance matters. These are all the topics that we will be discussing on our panel of expert discussion. So please join us on our Facebook group. We also have a Facebook group that you could join, and just to get all the information there that you would need and to be informed of upcoming seminars. We will be streaming this to at least platforms. I see that we have quite a number of people joining us from our website. There's quite a number of people joining us directly streaming from our website via our YouTube channel. We also have a number of people joining us from our website, from our Facebook page as well. There's 2 Facebook pages that we will be streaming to. Obviously, the one is Lunch and Learn. So if you have not been there, please join our Facebook group as well. So let's just start off with our webinar and what we will be discussing today regarding child maintenance. So we will be discussing shortly what is the legislation that deals with child maintenance. We will be discussing the common law duty of support and who needs to support by both parents. We will touch on the different forms of maintenance, being maintenance for children, maintenance for minor children, that is under the age of 18. We will shortly make reference to major children, children that are older but are not yet self-sufficient or self-supporting, and we will touch on spousal maintenance as well. These will all be dealt with in future webinars quite extensively. We will look in today's webinar, we will look at the requirements for the existence of a duty of support with children, and also who can be described as a child in terms of the current legislation. And then we will touch on certain aspects on your rights or your obligations, and if you could claim maintenance, child maintenance from parents, grandparents, brothers and sisters, uncles and aunties, as well as step parents. And we will touch on the need for maintenance and the means to pay, and then we'll give you a short overview of the maintenance application procedure so that you can become familiar with what is the procedure, what can you expect at court. And then we will also be addressing some general information regarding on the process on how to claim maintenance. The structure of our Lunch and Learn webinars would probably look something like this. You would have pre-reading material that you would receive. You will get a link a day or 2 before the webinar starts, and you can log on to the website where you will have access to the pre-reading material. That is basically material just giving you some history. Feel free to read up on that at least a couple of minutes or an hour or so before the webinar so that you have quite an idea of what is going to be discussed. Then we will have the full webinar, which will probably consist for about 40 minutes or so, whereafter we would have a short panel discussion with an expert coming in and joining us on the webinar. And then you can also look on the right-hand tab. There will be a tab called Resources and Templates, where you would find all the templates, all the precedents, all the case law, and as well as the handout that we are referring to during the course of the webinar. So let's just delve right into it. Things that you should know before you apply for child maintenance. Like I said, there are a couple of number of acts that deals with specifically child maintenance, where child maintenance is mentioned in the act. The first one would be the Children's Act. Where there is quite a number of references towards child maintenance in the Children's Act. Of course, the Maintenance Act is our main source of knowledge and of know-how and the structure of how to claim maintenance, how to enforce maintenance, and all the remedies and defenses regarding child maintenance in terms of the Maintenance Act. The Constitution also deals with some aspects of child maintenance or makes reference thereto. Certain portions of the Divorce Act also gives us an indication what is considered child maintenance, as well as reference thereto in terms of the Domestic Violence Act. So if we start off by asking the question, what is maintenance? Then we have to look at the Children's Act, because that would be the obvious point of call. And in terms of Section 18 of the Children's Act, that deals with parental responsibilities and rights, it says that the parental responsibilities and right in respect of a child would include the responsibility and the right of a couple of things. And those things are to care for the child, to maintain contact with the child, that's obviously visitation, to act as a guardian of the child, and very importantly, in Section 18(2)(d), it says to contribute to the maintenance of the child. Strange enough, there is no definition in the Children's Act that specifies what is considered maintenance of a child. So one needs to look a little bit further. Then we turn to Section 15 of the Maintenance Act. And we'll come back to this portion a little bit later in more detail, where it says, the heading there says that the duty of parents to support their children is actually considered to be a maintenance order for the maintenance of a child that is directed to the enforcement of the common law duty of support by the parents. So that is basically a codification or a confirmation that the common law duty of support is pertinent and needs to be enforced by the Maintenance Act, where both parties, both parents, need to support their children. If we look at Section 28 of the Constitution regarding children's rights, we would actually see that the Constitution states that every child has the right to certain things, and some of those are to family care or parental care. So what is considered care? Or to appropriate alternative care if they are removed from a difficult family environment. The child also has the right to basic nutrition, shelter, basic health care, services, and social services. So what is meant by basic nutrition, shelter, basic health care? And then in Section D, it says that the children has the right to be protected from maltreatment, neglect, abuse, or degradation. So the common threads through the Children's Act, the Maintenance Act, as well as the Constitution of South Africa, read with some of the case law pertaining to child maintenance. It is very clear if one looks through all these acts and the case law that the primary focus is the best interest of the child. And we will be delving into that in a separate webinar to explain and to unpack what is really the best interest of the child. This primary focus of best interest of the child has also been confirmed by quite a number of case law. One, for example, is the Ballantyne versus Ballantyne case, which was ruled upon in the Supreme Court of Appeal in 2003, as well as SS versus VVS, which was handed down in March 2018. All these legislation, all these case law is available in your resource folder. So let's look a little bit at the common law duty of support and who needs to support. If one turns to Section 15 of the Maintenance Act, which deals with the duty of support to children, it states, and I'm going to read it very briefly so that you can understand this, without derogating from the law relating to the liability of persons to support children who are unable to support themselves, a maintenance order for maintenance of a child is directed at the enforcement of the common law duty of the child's parents to support that child. I'm going to read that portion again because that is vitally important. The maintenance order for the maintenance of a child is directed at the enforcement of the common law duty of that parent's duty of support towards that child. And then for a little bit more clarification in Section 15.2, it says that the duty extends to support a child reasonably requires for his or her proper living and upbringing, and includes the provision of food, clothing, accommodation, medical care, and education. And one could then argue that this might be included in the unwritten definition of maintenance. Maintenance would be the requirement, what a child needs for his or her proper living and upbringing, which would include the provision for food, clothing, obviously schooling would there be, accommodation, and medical care. Those are all the duties, all that the child would need as maintenance. So there are three different kinds of maintenance, and one needs to distinguish between these three. And I'll tell you later, we'll explain the importance of why it is important to know the difference between these. First of all, we deal with minor children. Now, minor children is children that is considered under the age of 18. So if one looks at the Section 17 of the Children's Act, where it says that a minor child is considered to be a child under the age of 18 years. And then we look at major children, that is children over the age of 18. So yeah, could children over the age of 18 years, even if they are considered to be major children, could they claim maintenance? And we'll be discussing the case of Z versus Z a little bit later on. And then there's, of course, spousal maintenance. Now, spousal maintenance comes as a direct result of people divorcing and then claiming spousal maintenance because there's a reciprocal duty of support amongst spouses. But spousal maintenance is such a complex and such a detailed issue that needs to be dealt with separately, and we will delve into that quite extensively in future webinars. In general, when one thinks about the requirements for the existence of a duty of support to children, in general, the parents are obliged to maintain the children if there's a couple of things at play. The first thing would be that the person liable to maintain the child must have the means to supply such maintenance. So what does that mean? It basically means that the person that is asked to maintain must be able to do so. Point number B is that the children are incapable of supporting themselves. Obviously, children under the age of 18 is not self-supporting, so they are entitled to maintenance. But then you would have the question of people older than 18, and how does one deal with those? Because they are not self-supporting, but yet they are also dependent. They're still dependent on the parents. And then if we want to look at the last one, there should be a relationship between them is of such a nature that the law would actually recognize the existence of a duty of support. And we'll get to that in a couple of minutes when we discuss claiming maintenance from aunts and uncles, step-parents, and so forth. So let's delve further. What is considered a child? Who can be considered to be a child? In terms of Section 17 of the Children's Act, the definition is quite clear. A child is considered, whether it's male or female, to become a major upon reaching the age of 18 years. So that is why it's very important to distinguish between child maintenance for minor people or minor children and for major children. So a child is considered to be less than 18 years old. In a recent case that was handed down in 2021, the case Z versus Z, the Supreme Court of Appeal has ruled that parents now can actually claim on behalf of their adult dependent children. So if the child is still dependent, he's still not working, he's still not self-sufficient, then that parent could claim child maintenance on behalf of that children. In that judgment, the court said that different interpretations of the Divorce Act has led to conflicting rulings when parents should claim maintenance on behalf of their adult dependent children. That was quite evident in court practice and in courts, because the courts would basically just say upon the reach of the age of 18 that a child needs to go to court on their own to claim maintenance, because in terms of the Children's Act, in terms of Section 17, that age is of maturity is 18 years old, and then after that, a person or child is considered to be a major. So Z versus Z came in, that court case came in and said, and they recognized the need for a child of 18 years and older that is not yet self-sufficient, not to be exposed to this whole court system and to claim maintenance themselves, but whereas the parents could still claim maintenance on behalf of that child. So this judgment stated that both parents remain responsible for the upkeep of the children during and even after the divorce, up until a stage where they are self-supporting. So now we come to the question of who can you claim maintenance from? Claiming maintenance from parents, grandparents, brothers and sisters, uncles and aunties and step-parents. So let's off, while we all know that obviously there is, and we emphasize that in terms of Section 15 of the Maintenance Act, that the parents have a common law duty of support. So what is considered to be a parent? A parent in terms of the Children's Act includes any adoptive parent of a child. So it's basically biological parents, but it excludes, there is some exclusions where parents are not considered to be parents. And that would be the biological father of the child conceived through rape or incest of the child's mother, or any person who is biologically related or being a donor for purposes of artificial semen fertilization, and a parent whose parental responsibilities and rights in terms of that specific child has been terminated. So even if you have parental rights and responsibilities and a court ordered that your parental rights and responsibilities have been terminated, then you are not considered to be a parent. So if one looks at the left-hand side regarding parents, so both parents, like we said so many times, have the duty of support towards their natural children, whether they are born in or without a wedlock. So it could be legitimate or even illegitimate children in accordance with their respective means. So they are liable for maintenance for the children, regardless if they are married or not married, in accordance with their respective means. It is very important to note that a parent's duty of support in respect of their children is not terminated by divorce or remarriage, or even the fact that only one person or only one parent has care and contact of the children. It does not stop there. Even if the child is not staying with you, or you are being denied visitation rights, you are still liable to maintain that child up until a stage where that child is self-sufficient and self-sustainable. Next, we come to the claiming of maintenance from grandparents. And then one should note that there's a reciprocal duty of support between grandparents and grandchildren. However, there's a big but. But that duty of support can only be sought, can only be granted, can only be asked for if the nearer relative, like the father, is not able or not forthcoming in paying maintenance. So if the parents are incapable, both parents, mother and father, are incapable of supporting the children, then the grandparents are on both sides of the children, can be obliged to support their children. And this is quite a contentious issue. And we will be delving into this in future webinars quite extensively. If one looks at brothers and sisters are liable to maintain another if the parents and the grandparents are not able to do so. That would also include half sisters and half brothers. But the claimant must prove that he actually needs the maintenance and that the brothers and the sisters are actually able to provide such a support. So it's not something that is commonly used nowadays in courts, claiming maintenance from brothers and sisters, but it is also available. I've seen one or two cases where that has happened. Uncles and aunties, there is absolutely no duty of support between more remote blood relatives. Like I said, specifically like the grandparents. You first go after the nearer, the closest parent, the closest relative, before you go further. So in terms of uncles and aunties, there is no duty of support, no duty for them to support the child, even if the mother and the father cannot pay maintenance, because they're very, very remote blood relatives in relations to affinity. Step parents, there is no duty of support between remote blood relatives. That's just very technical details in the collateral or line by affinity. So the bottom line here would be that the step parents have no duty of support towards the children. Cohabitees, people living together in either same-sex or heterosexual cohabitees in South Africa. There was a couple of cases that was presented, and the general feeling was that at this stage in South Africa, there is no duty of support. If you only live with someone and it is not your child, then obviously there would be no duty of support. So if you have a live-in boyfriend or girlfriend and you have a child with a biological father, and the biological father is not living with you, you cannot hold the cohabitant, the partner that's living with you, responsible for claiming maintenance. The need for maintenance and the means to pay maintenance. So while there is a legal duty on both parents to support the child financially, the exact contribution would be proportionate to what each individual earns. This is quite important. And on my Facebook group, we see that so often that we get the instance where people say, you know what, child maintenance is 50-50, and that is totally wrong. There is no such thing in the South African law to say child maintenance is split 50-50. Even if parties agree to that, that's a different ballgame, because they could do that in terms of a divorce agreement stipulating the percentages that they would contribute, and that might amount to 50-50%. But in general, as a general rule, in the maintenance courts, there is no such thing as a 50-50 split. The Act and the case law is very, very explicit regarding that the exact contribution will be proportionate to what each individual earns. So that could happen that mom earns less than the dad earns much more, so then proportionate, the dad would pay more towards maintenance than the mother. But the thing of 50-50, there is no such thing. This means that the contribution won't necessarily be equal, but it will be fair. So now fairness comes into play as well. And to help determine what is appropriate, the maintenance court will determine the reasonable maintenance needs of the child and weigh it against the individual parents' means and income. So the income and the means of the one parent of both parents would be scrutinized, would be looked at, would be considered in order to make a division for maintenance proportionately that would be fair. We will definitely discuss this in future webinars quite extensively. So if one looks at the next diagram, just a short overview of the maintenance application procedure. And I think that is quite important so that we can understand what is going to happen in court. What can we expect so that our expectations are met? Where do we go from here now? We've learned in this webinar now what is considered to be a child, who can you claim maintenance from, and we've spoken very broadly just to give you an indication of what to expect for future webinars as well. So in short, you would have a complaint. The complaint would be lodged in paper form. Unfortunately, we do not do that, or it's not possible to do that electronically yet, but there needs to be an application for maintenance form, which is called the J101 form. We'll go into that much detail later on, where you need to give that form. You have to hand that form in at court. The maintenance clerk would then take the form. They would give you a case number or a maintenance reference number, and the matter would be given to the maintenance officer. The maintenance officer would look at the paperwork that you've submitted, and we'll discuss probably in the next webinar on what documents do you need and how do you prepare to get all the documents ready. So you take the bundle of papers and the application form, you give it, hand it into court, and then the maintenance officer would go through the documentation and scrutinize that documentation. Then the father needs to come to court. So there would be a directive issued, a Regulation 3 directive, where the father would come to court and he would come to the office of the maintenance officer for a Section 6. You will hear me referring to the Section 6 and the Section 10 maintenance inquiry. So he will be invited to come to court for a Section 6 informal maintenance inquiry. So dad would come to the office of the maintenance officer and they will discuss this matter of you wanting to claim maintenance. During that process, there's certain things going to be happening. His rights will be explained, paternity will be addressed, all those things, those nitty-gritty, but we'll discuss that later. So that will be done in the office of the maintenance officer, and if possible, there would be an interim maintenance order made if he is the father of a child, if he does not dispute paternity. Then possibly an interim maintenance order could be made, or if the father agrees to the needs or the wants of what the mother needs for the child, then a consent order could be made, and that could be made in order of court. If for by chance that the father does not agree, the matter would probably be postponed for a later date, or if the father does not have all the information available, then the matter would be postponed to get banking statements, and we'll explain to you later on how to read and to interpret all these bank statements, what questions to ask during this Section 6 inquiry. So after the Section 6 inquiry, if the parties do not resolve the matter, the maintenance officer could transfer the matter or refer the matter in terms of Section 10 for a formal inquiry to court. And that is done formally in court, where a maintenance magistrate will sit in front. He or she will look at all the documents presented. You will be required to testify under oath and to explain the needs of the child and what you need for maintenance per month. They will also scrutinize your income and the income of the father in order to make a fair assessment and to make a fair ruling regarding maintenance. That is, in short, what would happen in a maintenance court. So just before we get to the panel discussion, general information that is also important to know. The one is jurisdiction. The court must have the ability or the right to hear the matter. So where do you go to? Which court do you go to? If you start off with, it's quite daunting, you know what, you need to go to court. So which court do you go to institute all these proceedings? And it is established in terms of legislation that it could be instituted in a maintenance court within the area of jurisdiction where you live or where you work or where the children are. So those are the three jurisdictions of courts that might have jurisdiction. And that could be three different courts, because you could live in one area, you could work in another area, and the child could reside in a different area to get probably with a grandmother or auntie or whatever. So all those three courts would have jurisdiction to hear the matter. Just a short note on who to apply or who may apply for child maintenance. The enforcement of the rights, very important to note, is Section 15 of the Children's Act, where it says that anyone listed in this section has the right to approach a competent court. Very importantly, a competent court alleging that a right in the Bill of Rights or this Act, the Children's Act, has been infringed or threatened, and the court may grant appropriate relief regarding that. So there's a couple of people that might approach the court for such relief. It could be a child who's affected. Usually, if it is a minor child, it would be done with the assistance of the mother. That is usually in the case of maintenance matters where the one parent, usually the custodian parent, the person that has custody of the child, would go to court and ask for a maintenance order. For the attendees of this webinar, if you look under the resource section, there is a free book that was written by myself and my colleague, and it was written in plain language. We've updated the book to the 2023 version. It's a book that it's an ebook that is downloadable. Please, you may distribute that. You can forward that to somebody else that needs it. It is free for you to use. I can probably just share my screen so that we can look at what is in the book. Yes, there it is. So it is all about child maintenance and spousal support. These are some of the topics that we will delve into later, which would also be addressed in future webinars, but it would include things like what is required from a parent to claim maintenance, what to expect on the day of the court, what factors can be considered when determining child support, will there be any consequences for non-compliance. I'm just skipping some of these. What is the roles of different people in court? What is the role of the public prosecutor, the maintenance investigator? What does the maintenance officer do? This ebook also deals with spousal support or spousal maintenance. What is that? How to prove that you need that because it's not considered to be a right. There's also a list explanation of the calculation of the expenses. These are just everything that you can look forward to in this ebook, but it is free for you to download, read through that. That would give you quite a good indication of webinars to come, and just to have some background information on child maintenance in general. Let's just see what is next. Our next slide. That's the ebook that I've spoke about. Yes. Before we get to the questions and answers, we'll have this short discussion where Advocate Dion Reiters will be joining me. He is the senior maintenance prosecutor for the Western Cape. So we will be having a short discussion, and then we will open the floor for questions and answers. Because our time is limited in terms of a lunch hour, we would request people to either send us a WhatsApp message or to drop us an email on info@lunchandlearn.org.za in order to pose their questions, and those questions will be addressed by the panel of experts. Right, so joining us today for our discussion panel is Advocate Dion Reiters. He is the Senior Maintenance Prosecutor from the National Prosecuting Authority. So let's just jump right into it. Advocate Reiters, your comment or your idea on a tip. What should the people out there know before they even could consider applying for maintenance? What would you offer them? What advice would you offer them?
Well, Eugene, to start off with, I think it's important that they should know that they can approach the maintenance court closest to where they are staying or where they are working. That's in terms of the Maintenance Amendment Act 9 of 2015 that states that the applicant can apply for maintenance at the closest court to where she is living or where she is working. That is the way that the legislature and parliament decided to make the law more accessible for the person on the street. And
or the approach to the court, so they can actually approach the court where they live or where they work.
Wonderful. Yes, that's what they can do. Tip number 2 will be for them to know that I know sometimes it's a daunting task in order to apply for maintenance. You don't know where to start or whatever. I've got some good news for our listeners and viewers. In that specific case, they need to know that in terms of the Department of Justice's policy on maintenance, maintenance clerks are there to assist them with completion of the J101 or J107 application for maintenance. So they don't have to worry about that. but they must also bring their own side to the table in order to make sure that they know the exact expense they have for a child, pertaining to how much they are spending on electricity, how much they are spending for food, how much they are spending for school fees, how much it is to take the child to school. So they can't come to the maintenance court and say, I don't know how much to ask, or whatever the case might be. They need to know what the expense of the child is in order then to claim maintenance.
Okay, so we'll definitely get into that in future webinars. We will explain more in detail what is needed and all the documents that's needed for claiming maintenance. Just another question, a discussion around which court to use. You've mentioned the jurisdiction of the courts, where they live or where they work, which makes it more accessible. But is the maintenance court the only court that could be used to claim maintenance?
Now, the Section 16.2 of the Maintenance Act says any court can make a maintenance order. So that by that reading, it shows that it is not just limited to a maintenance court. Uh, in our modern era, there's a lot of cases that end up in divorce. So the divorce court also have the inherent jurisdiction to also deal with a maintenance, in the sense that in terms of the High Court rules, 43 of the High Court rules, a high court can make a 43 interim maintenance order. A regional court can, in terms of a 58, make a maintenance order. So there are other courts that can also deal with it. Children's Court can also deal with it in terms of the Children's Act. Section 33 of the Children's Act provide that a parenting plan can include maintenance. So that's another source where the other courts can also make these maintenance orders. Then there are also the case of domestic violence, where the domestic violence legislation have a provision where you can have emergency fund financial assistance that can be made by the
Emergency
domestic violence.
monetary relief, I think is the right wording.
Emergency
Monetary relief. That's
Yes,
correct. Section 7.
that's it.
That's
Yeah.
correct. Just another question on the claiming of maintenance from grandparents. Can you just briefly have a short discussion? We've got about 3 minutes left on the discussion portion. Just what is the situation with practically claiming maintenance payments of contributions from grandparents?
Okay. In short, the respondent or father will not have sufficient means, meaning that he do not have the amount that the applicant is claiming for maintenance. The maintenance officer will then make a recommendation to the court and say that, Your Worship, the respondents of limited means, therefore I request the court make an order that the respondents be added, the grandparents be added as respondents in the specific case, because the respondent, first respondent being the father of the child, do not have sufficient means. But it doesn't mean that it will only be the father that will be added to the claim, but also the mother's parents will also be added to the claim.
Both grandparents will be added.
Grandparents, whoever's alive will be added to that specific claim.
Okay, thank you very much for that. Right, now we turn to some questions and answers. You are most welcome to email us your questions. We had a couple of questions come through on info@lunchandlearn.org.za. In order to save time, it would be a good idea if you could just pop us an email through, and then we would discuss those as they come through. The first question came from Tomifuti from Frankfurt. She says, she was told by the magistrate court to bring all my slips, and I did not have all the slips, or I do not have all the slips ready. Yes, that was pretty much addressed in the discussion portion, where Advocate Reuters said that there is still a responsibility on the respondent or on the claimant to bring all the information needed. Well, I found in practice what also could work, because, I mean, whoever keeps all their slips, now you are expected to bring a whole black bag full of slips. Please don't bring a black bag full of slips to the maintenance court. They will definitely not entertain that. My suggestion would be to what I advise some of my clients is to simply go onto the website like Pick n Pay, for example, and then you create a shopping list, and to say, you know what, you buy 2 breads, 5 bottles of cool drink, or you buy so many cheese and so much of meat, and then it all adds up to say, right, that's your grocery list. And then at the end, it says add to cart, and you all add that to the cart, the little icon, and then you print that out, and that by that way you can actually show the court, you know what, this is my grocery list that I have for a month that I need to buy for the child, and then that would suffice. In most instances, that would suffice. But if you do have slips, remember now, this is all in the preparation phase for you to get your application to court. So it might be good if you consider claiming for maintenance that you actually from now already get those slips together, because they might ask for those slips as well. But the idea of creating a shopping list from a site like Pick n Pay, for example, would in most instances suffice. Right, let's just see if we've got another one. Yes, we've got one from Cynthia that says that she's got a problem with the maintenance staff. They're not helpful, and English is not a first language. And they say at court that they don't have a court interpreter. Yes, we find that quite often where ladies are just turned away, or they just get the applications forms from the security guard, and they need to fill that in, and they don't know how to complete the forms. Advocate Wright has made brief mention to that. In terms of the DOJ Code 26 of 2015, that's a policy document by the Department of Justice, issued for personnel in the maintenance section, the family courts. It clearly states that the maintenance clerk and the maintenance officer needs to assist those people that cannot complete the form. So there is no excuse. If the staff are rude, then I would suggest that you look at the boards. There's always at every court, sorry, at every court there is a board with the office manager and the area court manager's details to lodge a formal complaint to say that you have not been helped. But in most instances, once you get there and you say you don't know how, that they are obliged by law or by their policy document, the DOJ Code 26, to assist you. Most courts have interpreters employed. So if English is not your first language, then the form could be filled in Afrikaans. But although most courts would say that they would prefer doing that in English, because English is mostly used in the courts. But if you do not understand that, ask for the court interpreter. Sometimes the court interpreters are busy in other courts. They might be busy in the criminal court, so they might not be able to assist you immediately. But ask for them, make an appointment with them, so that they can actually assist you together with the maintenance clerk in order to help you with the application form. Right, that is basically all that we have time for. I thank all the people for attending. This was absolutely brilliant. This was our first run. So if there was a couple of hiccups, then we do apologize for that. Surely it will get better. The next one will be next week, same time, same place. Grab your cup of coffee, grab your sami, and let's learn. If there's any other questions, please drop us an email on info@lunchandlearn.org.za. And we just want to extend our sincere thanks to Advocate Reuters for joining us on the panel. This is Eugene Opperman. I'm a family law practitioner practicing specifically in child maintenance, domestic violence, and Children's Court Act. And this was for Lunch and Learn. Thank you so much for joining.